Should a student that exploded bottle bombs off campus outside of the school day be expelled from school? Should a teacher be allowed to punch a student at the student's home after school hours to discipline that student? We're going to look at the guidelines for school suspension, school expulsion, and student discipline for off-campus behavior. We're going to look at the expulsion and suspension guidelines that are listed within our book. You need to keep in mind that each state Department of Education can also come up with their own, as well as the district offices and the schools. There's not much difference, but they can vary from state to state. School suspension is a legal form of discipline intended for students who violate school or district policy that often involves issues relating to school safety. In-school suspensions are growing in popularity, and race, ethnicity, socioeconomic status often are factors that have an impact on school suspensions. There are a larger number of minority students of lower socioeconomic status suspended yearly rather than other students. School suspensions require that students' due process be met. Due process of law is a fundamental right guaranteed to citizens of the United States under the 14th Amendment of the Constitution. And basically, due process is a course of legal proceedings following established rules that ensure enforcement and protection of individual rights. Well, adequate notice under those rights must be provided to students and parents regarding the existence of rules governing student behavior, and they should be clearly communicated to all those affected by this implementation. A record should be compiled, and it includes an infraction allegedly committed, and time and place that it happened, and any witnesses, and finally any efforts that were made in advance as remedies to what was going on with misbehavior. Students facing suspension should at minimum be provided some type of notice, followed by a brief informal hearing. And students should be provided either oral or written notice of charges against them, and the evidence school authorities have to support the charges, and the students should be provided an opportunity to actually refute the charges against them. And because permanent removal is not intended, there's usually no delay between the time notice that is given to students and the time of the actual hearing. In fact, most administrators informally discuss the alleged misconduct with students immediately after the incident's been reported. And during the hearing, the school officials should listen to all sides of the issue, and they need to give adequate time to the students to present their side without any interruption. The parents should be informed of the hearing and given written notification of the actions that result from that hearing, and that written notice should include the charge that was brought against the student, along with the evidence used to support the charges. They should also be notified of the number of days of suspension and whether the suspension is in school, out of school, and they need to be given a list of conditions that must be met before the student can return to school, like a conference with a parent. A statement that informs the students that the suspension can be appealed is also included. Finally, the parents should be informed by phone at the suspension, followed by written registered notification, and that should be mailed out promptly on the day that it's actually happened, the suspension actually happened. And these are the guides in gray that Margie told us about. These are awesome. And this one can be found on page 88 for suspension. Unlike suspension now, expulsion is considered one of the more severe forms of discipline because it involves long-term separation from the school district, in some instances permanent separation. Expulsion usually involves more serious offenses or rule violations, and those vary from state to state as well as school to school. And school officials have really been challenged to maintain safe school districts in recent years because a significant number of expulsions have been linked with weapons violations. Threat of expulsions is so serious that parents and students and citizens, everybody involved, school personnel, should be involved in the development of the expulsion policies. And they need to recognize that almost every single state, the Board of Education has the ultimate authority for approving such policies. In addition to this, too, should be written very succinctly, sufficiently definite, the book says, and clearly communicated to the parents and students. There's two things that must be considered when creating these policies, and I'm reading these from the book. Number one, the unlawful activity reasonably may be considered an interference with school purposes and an educational function. Or number two, the student's removal is necessary to restore order or protect persons or school property. The following slides, if implemented correctly, will make sure that the constitutional rights of the students are protected to include their due process. And in this case, students and parents should be informed based on school and district policy, specific infractions that may be a result of the expulsion. And they should also be informed of the 14th Amendment rights regarding the due process there. The student is entitled to written notice of the charges and a right to a fair hearing in cases of serious misconduct where serious disciplinary measures are imposed. And that written notice must be furnished to the student, the parent, or guardian well in advance of the actual hearing. At a minimum, these are the procedural steps that should be considered. Again, a written notice given to the parents, a right to a fair hearing, right to inspect evidence, right to present evidence, right to legal counsel, right to call witnesses, right to cross-examination and to confrontation, and a right to right against self-incrimination, and a right to appeal. And these again can be found in that great guide, and this one's on page 91. So, in short, when comparing suspension to expulsion, suspension, short term, usually 10 days or less, and meant to correct behavior without them having to miss so much of an educational opportunity. And expulsion is usually long term, and it can even be permanent. Suspension, usually non-adversarial, with the principal suspending the student after minimal due process, such as oral or written notice, and a chance for the student to refute the charges. Expulsion, however, usually the school board hears the case and makes a decision. The parents or student can also take the case to the courts. Expulsion's full due process procedural steps and legal counsel is permitted, but for suspension, legal counsel is usually disallowed. And you can see in the book, this is table 3.2, summary of differences there. And this is on page 92. As far as student discipline for off-campus behavior, the book states, and I quote, "The courts have long held the view that the seriousness of an offense, rather than the place in which the offense occurs, determines the right to punish perpetrators of the offense if the act tends to immediately and directly affect proper school discipline and decorum in schools, or make them less effective. The jurisdiction of the teacher extends beyond the school to acts committed away from school and after regular hours. If the effects of acts committed beyond school hours reach within the schoolroom during school hours and are detrimental to the good order and the best interest of the students." You know, the bottom line, again, is that it's important that you as an administrator formulate valid discipline policies governing student behavior after school hours, during school hours, in school, and away from school. To-do list. Let's talk about some court cases that were in the book, and then we'll leave it open to discussion as well about court cases and your perception of out-of-school behavior and discipline.